Good evening, good evening, good evening. So, tonight we are going to get into business trust. Okay, I think this may be one of the most requested topics. So, I decided to bring on some vets so we can kind of talk about what is a business trust, why do we need it, what is the benefit of it, what is the difference of a business trust and a holding company, do I need a trust, how do I form a trust, all these good questions that everyone keeps asking. If you are just logging on, let me bring in. Tonight, we are going to be talking about the benefits of trust. We're going to be talking about why you may or may not need a trust. We're going to talk about what a trust is, how to form a trust. We're going to kind of get into the nitty gritty of business trust. Okay, so first, let me introduce my guest tonight. This is going to be attorney Charlie Hands. How are you doing tonight?
Oh, good, Joy. How you doing tonight?
I'm doing awesome. So, for the people in the back who don't know who you are, Charlie, tell us, who are you? What do you do? And your favorite Beyonce song.
Oh, wow. Oh, that's easy. Well, I'm gonna start with Beyonce song. My favorite Beyonce song is "Drunken Love." Like that.
Okay, okay,
That always.
Charlie,
Yeah,
okay.
I be feeling that Beyonce song. But yeah, I'm from Wilmington, North Carolina. Live in Charlotte, North Carolina. I'm an attorney, and I focus on, I call it legacy planning, trust planning, estate planning. There's many names for it, but that's my focus in Charlotte, North Carolina.
Okay. So let's just get into the nitty gritty. Okay, what is a trust? Everyone wants to know, what is a trust? Do you form it at the Secretary of State? Is it just paperwork? For a fifth grader, Charlie, what is a trust?
A trust is like a big toy box, and everything that you own are toys. And once you get your toy box, you put your toys in the toy box, and that's how you have your trust funded. You have everything in your trust, and then the toy box has a list of instructions that's on the box, and whatever you put on the instructions will happen with your toys.
Okay, so a trust is a toy box, and our assets are the toys,
Mhm.
and we put the toys in the toy box or the trust, and then we have to give instructions for the toy box, and then whatever those instructions are, that's what's going to happen to the assets.
Absolutely. That's simple.
What if I don't have any assets? Am I still able to form a trust?
Yeah, you are, because it's just like if you don't have any toys yet, you can always go and get a toy box or make your own toy box, and then later get some toys to put in there later.
Okay. Now, a holding company versus a trust. What is the difference between a holding company and a trust?
A company, a business, is just a toy, right? So that's something that you own. You can create it, but it's just one example of a toy, just like a car. So a holding company is a toy that you create. It's a business, and then that business is owning other businesses up underneath it for different reasons that we can get into. But then that holding company, again, is just a toy, and you're putting that holding company into the trust.
Which would I form first? Would I form the holding company first, or would I form the trust first, or does it not matter?
So in a perfect world, if everyone had all the information, they would make a trust first, then they would make their holding company, then but that's not usually what happens, especially with entrepreneurs and business folks. So they usually already have their business or already have their holding company, and then they might be finding out about trust tonight. And then,
Right.
but that's totally fine. You can already, just like having toys, you already got your toys and you need a place to put all these toys. You can then on the back end get a trust created
Okay.
and then put your holding company into that trust.
So in the perfect world, we would form our trust first, and then the trust would be the member of the holding company?
No, yes, absolutely. Because without the trust, you as yourself, so me, Charlie Hands, I'm the owner, the member of that holding company. I'm the owner. The trust would then be the owner or member of that holding company instead.
So in a perfect world, we'll form our trust first, and then we'll form our holding company. If we already have our holding company, we can file some paperwork to then form the trust, then backdoor and have the trust own the holding company.
Absolutely.
Okay.
Yep. That's
Okay.
it.
So technically, a trust is physically it's a piece of paper that owns assets.
Yep. So physically, it's sheets of paper. It could be 40, 50 to 90 pages. Pieces of paper with ink on it that has on the first page trust at the top. Whatever you can name it, whatever you want. It can be the Charlie Hands Trust, the Mickey Mouse Magic Kingdom Trust. Most people use their name if they want to like keep their name continuity, so they'll have like their last name, Family Legacy Trust, or something like that. And yeah, those are just sheets of paper. But unlike businesses, where businesses have to be registered, usually with a state Secretary of State, the trust is a private document. It's a private family document that you don't usually have it see the light of day. And then that entity, the trust, is going to be the thing that owns everything that you have in a business, such as the holding company. And then the holding company can own bank accounts or other companies up underneath it.
So basically, you're saying that everyone won't be in your business as to what you put in the trust because it's private.
Absolutely. That's one of the main benefits and purposes of why trust law was created, for privacy.
Now, let me ask you this, Charlie. What if I have some personal assets and I have some business assets? So I may have like a home and a car personally, but I may also own a trucking company and I maybe own 5 or 6 trucks. Would I put all of those assets in one trust, or should I have different trusts for different types of assets?
Yeah, so just most people, even business owners, they're gonna have one trust starting off. This is gonna be like creating level one. One trust in the company, everything's dumped into one box because the business entity is what's gonna have limited liability. So if someone you got in a car accident with one of those trucks in a trucking company, when they sue, they're limited to whatever that company owns, but they're not gonna be able to come through the rest of the trust to your personal assets, such as your personal house or your personal checking account. The buck is gonna stop at that business entity. But there are other options there when you get past that foundational level where you could add other trusts and do different things. But that's 9 times out of 10 what most of my clients are doing. One trust, everything in the box, all the toys in the toy box, and then that covers it with liability protection from the business entity itself.
If the business entity's corporate veil gets pierced and the trust is the member of the LLC, well, can piercing the corporate veil get to the trust assets or no?
I love that question. That's my first case as an attorney. I pierced the corporate veil against a slumlord. So yeah, in that example, if everything's in the trust, corporate veil is pierced, and then the trust owns that holding company, then that means that everything in the trust would be exposed, which is no different than what most people have when they personally, in their individual name, own their own holding company. If that corporate veil is pierced, then anything you own as an individual is exposed. Just so the trust doesn't change that unless you do some more advanced trust planning. And we can get into that if anyone's interested.
Um, is there just one trust or are there different types of trusts?
So really, there's 2 different types of trust. Now, there's like probably 50 to 100 different names people give different trusts based off the purpose. But there's a revocable trust. Some people call, or it's also called a living trust. That's 99% of the time what most people have. A revocable trust, meaning I make the toy box. I'm holding the toy box in my hands. I can put things in the toy box. I can take toys out. I have full control. I created it and I have full control over everything in here. An irrevocable trust, that's when we get into more advanced trust planning. But that's when you create the box, but you put it off to the side somewhere and you put it in someone else's hands, and you're not holding the box no more. You can put toys in it, but as far as what's going on with those toys and as far as being able to control it, you have no control because you're not holding the box anymore. That type of setup does create the peak ultimate asset protection, because if someone sues, they're going to look at what's in your hands. If you don't have that box in your hand, then you're good to go. But it's not ideal for the typical business owner in every case scenario, because a lot of times you do want to maintain that control unless you have some arrangement with someone or some business entity that's, I'm a beneficiary and I have them like working with me, even though I'm not holding that box anymore.
So a revocable trust is where you would you have your trust or your toolbox, and you put the assets in the toolbox, but you can still play with the toys in the toolbox. An irrevocable trust is you put the toys in the toolbox, but you put the toys in the toy box and you no longer have control. You can no longer play with the toys because someone now owns and controls them.
Absolutely. You're not holding it no more.
Okay. So depending on there is no like one size fits all asset protection plan. Okay. So if you're thinking about forming a trust, I would say at least book a consultation with Attorney Hands and just have him kind of give you different scenarios, right? Every time we see a diagram on social media with the trust, holding the holding company, all these things, there's like different types of ways to protect your asset, and you want to make sure that you're doing what's best for you and what your plan is. So I know you've been talking about business assets, Charlie, but if personal assets, and then if I want to pass things down, like I know that I can use a trust instead of a will, right? Can you kind of tell us what are the benefits of having a living trust versus a will that has to go through probate court and all of those expenses?
Exactly. Just real quick, a will has no power until it goes into court. So you have a will, sheets of paper, you got witnesses on it, but it has to go through court, probate, the state administration. It has to go through this whole process that usually takes at least 3 to 4 months. It can take up to 8, 9 months, even years, depending on your situation and your court system, just to get those assets to the beneficiaries that's supposed to get them. A trust can have the exact same wording as far as who gets what in it, but it's instantaneous where you can avoid that court process 100% and have more of a seamless transfer to your heirs instead of them having to pay money to the court and deal with more time going through that process.
Okay. On average, what is the cost to forming a trust?
So I did a lot of research on this, and from my research across the country, is a minimum of $1,500 for a typical basic trust. 1,500, but it ranges dramatically depending on jurisdiction, where you're located, what type of trust you're gonna get. Like my average trust fees in North Carolina for the trust that handles everything that's airtight is $4,000 to $6,000. For that same type of trust in different states, I've seen people pay $8,000, $9,000, but I would say starting at $1,500, depending on where you are and what you're trying to do.
Okay. And just to do a recap, you would form the trust, and then when we say put the toys in the toy box, that means we would have to register our vehicle titles in the trust name. We'll have to put the deed of the real estate in the trust name. Is that what you mean by putting the toys in the toy box?
Yep. So you're just changing the title to everything, where if it's me, Charlie Hands, or Charles Hands does not own anything as an individual. Instead, this car is owned by Charlie Hands as trustee of the Charlie Hands Legacy Trust. It's just adding more words to the paperwork, but what it means is the trust is the owner and I'm on there as a trustee of my trust as opposed to just my name, John Doe, owning something as an individual.
Okay. So would that also be the same as a holding company owning an asset?
The holding company is so again, the trust would own the holding company, and then the holding company would be on title for everything else the holding company needs to own. So usually for businesses, nothing changes. So if someone already has a business and you have a business bank account, a business checking account, you have your business credit, the business might own trucks. That all will stay the same. That holding company or that business will keep ownership of whatever it owns, but at the top of the triangle, so to speak, the trust is owning it from the top. So that means everything from down is going to be owned underneath that trust, ultimately, when you look at the big picture.
So you're saying title the trucks in the trust name or title the trucks in the entity
The
name?
trucks will stay owned in the entity name. And the only thing that would change is the entity is owned, the holding company is owned by the trust. So the holding company is owned by the trust, but the holding company will keep ownership of everything else.
Okay, so just to clarify, hold on, let me get my paper. Because I teach it a little different, okay? So in the scenario that Charlie is giving, and if you're just logging in, I am going to repost this live. And in the live, in the caption, I'm going to tag Charlie's law firm so you guys can start booking your consultations, okay? So just so my followers can understand what we're saying and we're on the same page.
All right.
Where you're saying holding company, I like to call that the parent company, because I teach that the holding company should not own any assets. So in case they are sued, that business entity won't lose those assets. So let me just give me a little diagram.
Yeah, and I agree. Parent company owns child companies.
So we'll have the trust that will have the parent company, which Charlie is calling the holding company, and that's going to own all your LLCs, right?
Yep.
And then you'll have a holding company either own the assets or your trust would own the assets, and then we can just lease those however you want to do it. But you do not want to be doing business with an entity that has an asset, because if you were to get sued, then you would lose the asset. Now, depending on where you are in your business walk, right? If you are just a startup and you are on this live, we do not need to go pay all this money, and we don't even have like our business started, but you need to know what is on the to-do list, right? So we have trademarks, we have trust or holding companies, we have all these things on our list as to what it is that we need. So when you start making money, we can now knock some of these things off of our to-do list. If you are a seasoned business owner and we have some assets, right? Whether they're personal assets or business assets, $1,500 to $5,000, I'm sure is less than what the asset is worth. Okay, so either we can pay now or we can pay later. If we pay later, 9 out of 10 times, we're going to be paying more, okay? So whether you want to use a trust or a holding company, you can choose, but you need to make sure that your assets are being protected. So we have vehicles, we have equipment, we have property, we have real estate, we have trademarks, we have patents, we have copyrights, right? If we're owning things, they need to be held either in an entity or in a trust, okay? We do not need to own these things personally, and we don't need to own them in the entity that we're doing business in. So as we are acquiring these things, like Charlie was saying, we need to start protecting them. Okay, holding companies is one thing that I always talk about, but I want you guys to also understand trust. Okay, now as he said before, you can use the same trust to pass on your assets to your descendants or your successors or the people who you're gonna give the stuff to, and they're not going to spend all this money in probate court. Okay, probate court is very expensive. A will can be contested. You guys know your family dynamics. If y'all fighting at Thanksgiving dinner, you're gonna fight over this will. I wanted that, they didn't mean that. Boom, boom, boom. So now we have a contested will. All that's doing is burning up his attorney fees. Okay, when you contest the wills, Charlie gets half because that means he gets to go to work, right? But we don't want that. We want to preserve whatever it is that you're passing down to your kids, to your heirs, to your successors. We want to make sure that they're getting the bulk of that asset. You don't want to just burn that asset in probate court with court costs, attorney fees, and just wasting the money. And at the end of the day, we all gonna split $5 because everyone was mad. So if you don't have anything, we at least need to have a consultation as far as getting a living trust. A living trust would kind of take place of a will, okay? A will is where you're going to say, when I die, blah, 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 blah. You'll put that in a trust. So upon your death, whatever the trust says as to who gets what, who's going to take over your kids, who's going to do whatever, they get those things immediately. Is that correct, Charlie?
Yeah, absolutely. You are spot on.
Okay,
So
even if we don't have anything, right, we may die. Everyone on this live is going to die at some point in time, right? So when you die, who's getting what? So we at least need to book a consultation as far as a living trust to get those things in order. We do not want a will. A will is really just wasting money. Like I say, you don't want a DBA, you don't be asked out. We don't want a will. That's just wasting money. So we need to be looking at getting a living trust. Now, depending on how proactive you want to be, right? You're like, well, let me go ahead and just set my trust up and then have my trust on boom, 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 boom. Then you can set your trust up now and do boom, 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 boom. But you at least want to have a consultation to understand the trust. Do I really want to trust? Is the trust going to benefit me? How do I want to use the trust? If you're just logging on, Charlie talked about there's going to be a revocable trust and there's going to be an irrevocable trust. A revocable trust is where you put the toy in the toy box or you put your asset in the trust, but you still control the asset. You can still, control it. Where if you have an irrevocable trust is the highest form of asset protection. Is that correct, Charlie?
absolutely, because then it's not in your name.
So,
yep.
But irrevocable trust means once you put that asset into that trust, there is no moving it. I can't move it to go get. I can't move it out my trust and put it over here in my LLC and go get financing on that asset. I can't move that asset over here to go qualify for a loan, or I can't move the asset. Can you sell an asset in an irrevocable trust?
The trustee of that trust can, but you aren't able to do it yourself.
Okay, so you will lose all control over the designation of that asset, okay?
Absolutely.
If we have a family home that's not going anywhere and we're passing it down generation to generation, we do not need a mortgage, it's just going for the kids and the grandkids, well then that may need to be in an irrevocable trust. But once again, I want you guys to understand there is no one size fits all, okay? So I want you to have a consultation and just ask your questions, see what your options are, which kind of trust is best for you. Now, they've been getting some questions, Charlie, about a faith-based trust, a 508 trust, and a family office. Any of this ring a bell?
Faith-based. I just know, like, whatever you have going on, nonprofits, faith-based, anything you have going on, a lot of people will put names on it. But what me and Joy talked about today, there's two main trusts, and whatever you have going on, you can fit into theme of whatever you have in life.
Okay. No, you cannot be a trustee of an irrevocable trust. An irrevocable trust is bulletproof. Okay, that means no one's breaking this. Once that asset goes in there, you have no more say. Hence why you have the highest form of asset protection. Okay.
Yep.
So let me go in here. So a lot of you guys are putting different trust names. They're like Charlie said, we can have the Mickey Mouse trust, right? The Beyonce trust. We can have any kind of named trust. The two types of trust are going to be an irrevocable and a revocable trust. You name it however you want to name it, but either it's irrevocable, meaning once you put that asset in there, you have no more control control over it, or a revocable trust where you can put the asset in, but you still have a say as to what's going on. Now, life insurance, can that be an asset that's put in the trust?
Yeah, absolutely. So a lot of my clients, they have life insurance and they'll change the beneficiary to their life insurance to the name of the trust so that everything, when they pass away, will dump out and pay out into the toy box.
Okay. Okay, so let me see if we missed any questions. I am going to post, when I post this live, I'm going to tag Charlie's law firm page, and I'm going to put his website. If you want to do a consultation, see, a lot of times in estate planning, some estate planning attorneys, estate planning is dealing with trusts and succession law, right? So some estate planning attorneys may be more informed about like personal things, like a living trust and a will and all that kind of stuff, a power of attorney, a medical power of attorney. But there's going to be some estate planning attorneys that are very knowledgeable, like Charlie is, on the business side of using trust. Okay, so we have a personal side called estate planning, or we're doing trust on the personal side, but then there are business benefits to forming a trust. Okay, so I believe that you have to form the trust in the state that you're in, but you can have a consultation with Charlie to understand what kind of trust that you need. And then he has a network of attorneys who are also business estate planning attorneys who he can refer you to if you do a consultation that's going to be in the state that you're in. But you at least need to have the knowledge of what it is that you're wanting, what it is that you need. You can tell Charlie, well, this is where my business is now. I'm planning on doing X, Y, and Z. And he can kind of give you a plan as to how we kind of get what your structure should be. So going in, okay, well, I need to have X, Y, and Z. X, Y, and Z is going to cost me around blah, blah, blah. Let me put that on my Christmas list. Let me tell my boo, I don't even need that Chanel. Go ahead and give me a trust. I'm just saying, okay. Yes, a nonprofit can have a trust. Should bank accounts be under the holding company name?
Yeah, and before I start, just to remind everyone, I'm licensed in North Carolina, so any and all information is based on North Carolina law, but North Carolina follows the Uniform Trust Code, which covers most states in the country, and it's pretty uniform across the board. But if you come to North Carolina physically, even just to visit, and you could then work with me directly. But if you're getting it done and you're not coming to North Carolina, then we can find someone that uses my same system in the state where you're in. What was the question again, Joy?
About bank accounts. What if a bank account are only in the deceased person's name? Will the bank hand over the money? Okay, if someone has a bank account, that would be put in the trust, correct?
Yeah, that's a toy. We want to put that toy in that toy box.
So let me kind of break succession law down. When we are now going to form a trust, basically a trust is similar to an LLC. Is a trust an entity? It's not an entity. Is it an entity?
It's like an entity, but it's not the same as
right.
a business entity.
So when you're forming a trust will kind of serve like a pseudo person, right? So anything that you want in the trust, you got to put the trust name on it. So if you have a bank account, that bank account would then go be in the trust name. Whatever is in the trust is what your heirs or your descendants will get. Now there is something, I don't know what's called. It's been a while since I took succession law, and I went to law school in Louisiana. So our law is a little different than everybody else. Yeah. But there's something that you can put in where when a person dies, all of the assets that they owned, if they forgot to put it in the trust, would automatically go to the trust upon their death. Is that ringing a bell or no?
My trust plans have that. I have three backups that do that. Two will make it so that we don't have to go to court. Even if you forget, there's a bank account out there and you forgot to put it in the trust. There's two legal backups that can catch it, put it in the trust anyway. If those two don't work, the last resort is going to be a pour over will.
Pour
That's a will.
over. That's what it
Okay.
is. Pour over will. Okay.
But yeah, it's just we do have to go to court with that, so that's not what we want to do, and that's not ideal. But that's the worst case where we go in court, we read the will, and it says put this bank account that we forgot to put in the trust into the trust. Because we know once everything hits the trust, once it hits the trust, it will do exactly what you want it to do.
Okay, so when we're forming a trust, we then have to put the assets in the trust or put the toys in the toy box. So it's going to be some paperwork in getting deeds over, getting titles over, getting bank accounts over. We're now moving everything. We are physically moving whatever the asset is to the trust. Okay, so if you have a bank account and it's not in the trust and grandma dies, you're going to have to deal with whatever is that state law as to what happens to the money in the bank account. So you want to make sure that whatever assets you have, that they are being properly put into the trust. Okay, so it's not just I just fill some paperwork out and now I have a trust and now I'm done. Every time you acquire assets, you're going to have to then put them physically in the trust.
Absolutely.
Okay. Is there a rule of thumb on anything that you would not put in a trust?
I think you touched on that earlier, Joy. If it's something where you want to, and that's more like advanced estate planning, trust planning, in my opinion, where we want to separate things out for liability, asset protection. We could have a separate trust set up that's an irrevocable trust where, or like a holding company, if we're trying to separate things from each other from businesses.
So once again, it all depends on what it is that you're doing. Okay. Yep. If you're in business and you have a lot of business assets, you may want to keep the control over the asset, right? Things happen. I may need to move some stuff over to get qualified for a loan. I may need to move some stuff over because a lawsuit maybe. I may need to sell some stuff real quick to pay my mortgage. Like, it all depends on what it is that you're trying to do. Okay, everyone's situation is going to be different. Everyone's business entity is going to be different. So there is no, one size fits all. That's why I'm saying I'm going to post Charlie's law firm in the caption. Book a consultation. What do you have? What do you have going on? What do you plan on acquiring? And what is your end goal? What are you trying to do? How does a living trust align with either a revocable or an irrevocable trust?
So a living trust is
Go ahead. Revocable trust.
It's a revocable trust. And then the irrevocable trust is what we mentioned earlier, where you don't have control or access to it directly anymore.
Since trusts are kind of like an entity, do they pay any taxes?
So when people have revocable or living trust, nothing changes in taxes for the person because it's just an extension of you, and that basically has the same social security number as you do as an individual. It's just nothing really changes. But once we go into irrevocable trust land, after you pass away or you set that up and it's a box over here and it's its own separate thing, then trust then can have its own tax ID as a separate entity, just like a business does.
So an irrevocable trust will have a tax ID while I'm alive or once I'm dead?
If you create one while you're alive, then yeah, any irrevocable trust will have one, a separate tax ID. With my clients, they create trusts where it's a revocable trust, a living trust. While I'm living, I own it. I can put things in it, put things out. But then let's say if I have two kids and those are my heirs, when I pass away, my trust then converts into an irrevocable trust and benefit to my two kids. So that if my two kids then get married and divorced, everything I develop over my life that I have for my two kids is protected from that divorce. If they got sued while doing business ventures, everything in that trust I made for my two kids is protected. At that point, that trust, once it's an irrevocable trust after I'm gone, will have its own separate tax ID. That's the 99% of the time scenario that my clients are going with. Revocable trust while they're living, so they maintain control and ownership. And then when they pass away, it converts automatically to an irrevocable trust for their heirs.
So I have a house that's paid off and I want to give it to my son.
Mm-hmm.
So upon my death, the trust then turns to be an irrevocable trust. He gets married, but because the house is in the trust, the house does not become community property.
Absolutely. It's separate and it's something set up by Mama Joy made this for me. And then there's nothing I have going on in my life that will be able to access it because it's separate from me and the trust that Joy set up for me.
Okay, so if he were to get divorced, his wife wouldn't be able to touch the trust. If he had his own business and got sued, they couldn't touch the house because the house is put in their irrevocable trust.
Absolutely. Yep.
Is there if I have a, maybe let's just say I have property that makes income. So maybe I have an apartment complex, a duplex. Is there a way for the trust to collect the income and not pay out to my heirs until they're a certain age?
Yep. Absolutely. Yep. That's right on. So the trust can be its own money-making machine, just like a business entity. It can have income, it can grow, it can invest that income. So a lot of trusts will have investment managers, financial planners, where they're growing the assets. So that scenario I gave where we make that revocable living trust on the front end, it converts into an irrevocable trust for the kids, for example, and it keeps growing over time. That's the Rockefeller formula. That's what the Rockefellers did, and that's how they was able to, after every generation, keep growing it. So let's say you left that house and everything to your son, and then he's an adult now, and he has things going on. While he's alive, he can dump things into that trust because that trust says he's the beneficiary of it. So he can dump things in it while he's alive. And then when he passes away, everything that's there will be for his children. And then it can keep growing because it keeps compounding off everyone's life, every generation.
And so that's why you call what you do legacy planning.
Absolutely. Generational
Now
planning.
let me ask you this. Can he sell the house?
The trustee can sell it. So a lot of people, like a lot of my clients, I let them know, like let's say in that son mom's example, he could put himself on as a trustee of that irrevocable trust, but it's risky for asset protection because if he got divorced, a divorce lawyer would make an argument to a judge and say, Your Honor, he's the beneficiary and he's the trustee. He's the beneficiary and he has control over it. We need to treat that trust as if it's in his name. So it's risky when it comes to asset protection. But if a trust company like or a bank or even another person, if they're the trustee, that creates the asset protection so that then it's not able to be touched in the divorce.
Well, let's push rewind, Charlie. What is a beneficiary and what is a trustee?
A beneficiary is the person you're naming to say, hey, all these toys in this toy box, I want it to go to them. They're the ones that's going to get it. And basically, when we mentioned the instructions for a toy box, everything in the toy box is designed and benefit to that person or those people. It can be more than one person. The trustee is the person who is charged to make sure that that happens, to make sure that those toys go to that person, or if it's income, and we're talking about income coming into the trust, making sure that the trust is being managed correctly, it's growing. That beneficiary might say, you know what, I have a job right now. I don't need a distribution from the trust. Just let it keep growing. Mm-hmm. Or to the trustee and say, hey, I'm getting ready to buy a house. I need a down payment for the house. Can I get the down payment? The trustee would then just say, okay, gotcha, and just transfer from out the trust at that point. So the trustee controls and manages the distributions, but the trustee can't do whatever he or she wants. The trustee does have to follow if it's in that example, what Joy said for that trust.
Okay. So just to get some clarification, there's really just two types of trust, an irrevocable and a revocable. But if I have an irrevocable or revocable trust, I can name it. I can have a business trust, I can have a family trust, I can have a nonprofit trust, I can have a hunt trust. I can name it anything, but it's just two different types of trust.
Yeah, those are the real types. People just name, and it's like nicknames where they'll say, "Oh, I put the house in the trust, so I'm calling that a real estate trust." Or this is my land trust. I got some land in it. That's my land trust. But really, those are like just generic or just nicknames. But the actual legal names are: is it revocable? Do you own and control it? Or is it irrevocable, where it's out of your hands, and if someone sued you, it can't be touched? But then the downside to that is you don't have direct control over that trust at that point.
Now, can you form a trust without owning any kind of business or LLC?
Absolutely. Just like we mentioned earlier, if you can say I don't have any toys yet, but let me go and get my toy box so that when I do get some toys, or if I inherit some toys or from any source, I'll already have my box ready to go to put the toys in the box.
Let me rephrase the question. If I have assets, like personal assets, but I don't have a business or an LLC, can I still form a
Yep,
trust?
absolutely.
Can you change from having an irrevocable trust?
You can either amend the trust you have or just make an irrevocable trust from scratch. And again, that's going to depend on what are you trying to do or what's the goal. Most of my clients, they always start off with the revocable trust or the living trust because they don't want a sudden change in control. They want to just have things easier for their families if something happened to them. And then once that's like level one, step one, and then step two, more advanced planning, is then we go and start looking at, should we look at an irrevocable trust? Does that make sense? But living trust or revocable trust is where most people start off 99% of the time.
Okay. There's a question. How much is inheritance tax on a property?
That's going to depend on your state. So I can only speak on North Carolina. North Carolina has zero inheritance tax. And just to cover what for most people, there's a federal estate tax, but under the current tax code since 2016 or 18, that you get a coupon basically where if your estate is worth less than 11.5, there's an exact number, but about $11.5 million. If it's less than that, then there's no estate tax to be paid. So for most people, estate tax or inheritance tax isn't an issue, but state inheritance tax is going to depend on the state that you're in. North Carolina doesn't have any.
Okay. How do you use your assets in an irrevocable trust?
The trustee is going to be using them. So again, irrevocable means you don't have control or direction over it, but you can be the beneficiary. So everything in there has to be using your benefit. But the trustee is the one that's going to actually be doing it, doing the distributions. If it's time, the market is high, we need to sell this piece of real estate, the trustee is the one that's going to be at the real estate closing, signing the paperwork, signing the deed over for that real estate closing. But everything that's like such as proceeds will all be in your benefit.
So if I had my house in an irrevocable trust, I could still live in the house. I just can't sell the house. I can't encumber the house with a mortgage. I can't refinance it. I can't pull an equity line of credit out, but I can live in the house.
Exactly. And if any of those things needs to be done for your benefit, the trustee is entrusted and mandated to do those things for you. So it's just
Okay.
a middle person to do those things for you. And that's why you'll have that asset protection if something targets you in the future.
If you are married and you both own assets, can you share a trust or should we both have our own?
Good question. So most it depends on the married couple. Most of my married couples, they do a joint marital trust, a joint revocable trust. They both own it. They both have access to it, which is no different than a joint bank account or any joint things that they have. So again, that means that for them day to day, nothing changes. Hey, we already have joint bank accounts.
Mm-hmm.
Putting that joint bank account in the joint trust. But there's a growing trend and a lot of married couples who like to keep their things separated from each other. And so that's when you have what's called, it's not a legal name of a trust, but reciprocal trust, where it's like, hey, husband has his trust, wife has her trust, or just spouses in any genders. But then from there, they correlate with each other based off of their marital goals, but they're separated.
So you can also use that if maybe we're married and have kids, but one of the spouses may have kids outside of the marriage that won't fall under that same descendant law as the husband and wife.
Exactly. So if you have like a blended family,
Mm-hmm.
some of them will say, hey, let's just keep everything separate. We think that'll be easiest. But it's really a point of preference, because you can still account for a blended family with the joint trust, because you can get very detailed in those instructions that you
Okay.
box
Okay.
in the trust.
Okay. What happens when you exceed the limit of 11.5 million? You're gonna pay, what's the state tax? 40%?
Yeah, the state tax is pretty high.
You're
You
gonna
have
pay a 40% tax on whatever is the
40%. But if you're in a situation where you're over that amount, there's strategies you can use with trust planning to make different multiple trusts to avoid that. So if you're in that category of the game, then you can talk to an advanced trust planning attorney like myself, or anyone that's in my network, and we know how to account for that to still save on taxes from your estate tax, using adding other trusts into your picture.
How much are your consultations, Charlie?
So my consultations, this is what my system does, which is national, $750. But if you complete the homework that we send you and get it back to me within at least 3 days before the consultation, the $750 is waived. So I'm sure it's not a surprise that most people always get the homework in. And again, the homework is it's really like it just allows me to maximize our time together. It's an inventory of everything that you currently have. It's an assessment of what's important to you, such as estate tax, or making sure my assets are left to my children and not going to divorcing spouses. It allows me to see exactly what your pain points are, so that we can maximize our time together. And so people are more than happy to work on that, in addition to waiving that $750 fee.
Okay, y'all. So Charlie is $7.50 an hour, but if you do the work and you answer the questionnaire, and the questionnaire is going to be, so when you're sitting there, he don't have to now go ask all these questions and make the consultation longer than what it has to be. Okay, so do you have assets? What are your concerns? Do you have kids? Are you married? Do you have debt? Like, give him the game plan. You have to kind of give him your playbook. Hey, here's all the toys I have to play with. And then once he knows what toys you have to play with, now he can tell you how to set it up. Okay, so if you do your homework, then technically the consultation is free. Okay,
Absolutely.
that's to kind of weed out people who want to just call and just talk and don't have a plan. If
Yeah.
I own real estate under my LLC that was purchased under a business loan, can I move it into a trust?
Unless there's a direct stipulation that says the has to stay in that LLC. Um, yes, you can move it into the trust. And I will say again, 99% of the time, whether if it's a house with a mortgage still on it or anything with loans, the creditor does not care about you moving things into trust, because it's not selling it to a whole nother person for money, neglecting to pay them off. You're just rearranging how things are structured for your own personal estate planning purposes.
And a lot of times they're going to like that better, because you're really, not that you're protecting the asset because they own the asset, so you can't lose the asset, but it's like you're trying to put it in a better place once you pay off that loan. So having your home in a trust is like you kind of being proactive in your estate planning and asset protection. So 9 out of 10 times the lender is not going to have a problem with that, but you would have to ask them. Okay, can you explain the type of trust needed to prevent the new Corporate Transparency Act? The Corporate Transparency Act doesn't have anything to do with the trust. The Corporate Transparency Act is just the LLC or corporate, whoever owns these entities. You have to tell the federal government that you own them. It's not this big of a deal, baby. You're telling the Secretary of State that you own this entity. It's like the same thing. You're just telling the federal government. It only is going to affect you if you have an anonymous LLC, but you're already telling the Secretary of State that I own this LLC.
And Joy, I'm glad. I like how you break it down, Joy, because they word things and make it sound so scary and complicated, and it's like, oh,
you're gonna be fined $500 a day. Baby, it's nothing new. Okay, your Secretary of State knows that you own this LLC. Okay, so all you're gonna do is fill another form out telling the federal government. Guess what? When you file your tax return and you have an LLC or an S corp or a corporation, you're telling the federal government, I own this guy. I got a K1, or I'm filing a Schedule C with this business and EIN. So it's nothing different. Are trusts taxed annually, and are there special processes to handle taxes?
So revocable trust, again, is just an extension of yourself. Basically, nothing changes from your personal tax picture. If it's an irrevocable trust with its own tax ID, then yes, it's just like a person or a business. You have to file taxes on it, just like in those situations there.
So trusts don't have owners, they have beneficiaries.
Correct. You have the trust only has someone that creates it. That's called a trustor. But then once they create it, they kind of they go away. And then you have the trustee, who is the person who manages and controls. And then you have a beneficiary or beneficiaries, if it's more than one person, who is getting the benefits of whatever's in that box, in that toy box.
Can you HELOC property in trust, or should you HELOC before putting it in a trust?
So like all of my clients, they'll put it in the trust. Whenever they decide to learn about trust, they learn the benefits of it, and they immediately put it in the trust. And then let's say 2 years later, they want to HELOC. It depends on the underwriter. It depends on the lender. Some lenders say, oh, okay, no, we can write it as is. Worst case scenario, just like if you own property in an LLC, for example, they might say, no, it needs to be in the individual's name. So what all of my business folk do, or trust people do, just for that closing, they'll take it out the trust name and just have it in the individual name, complete the closing, and then put it right back into the business name or right back into the trust name once it closes. Because for that lender, if they do require it to be in the individual name, they just say during that closing period and due diligence, they might want the to be the title owner. But that's going to depend on the lender, because a lot of lenders don't require that at all. You can just leave it in the trust name.
Is there an extra fee each time you add something to the trust?
No. So the beauty of a trust is once you create it, again, like a toy box, and you got your box in your hand, you go to Target and buy a new toy, Walmart, you already have your box. There's no cost to go back home and put the toy in the box. There's a document that you get with the trust. It's called a certification of trust. So whenever you, like, let's say if you open up a new bank account, all you do is show that certification of trust, which is just 3 to 4 pages, and you just show that to the banker. They type on the computer, and boom, it's in the trust. So it's no cost to do it, and it's very easy to do once you get the hang of it and get used to just showing that document to whoever needs to see it. If you buy a new car, you show that to the DMV or to the car dealer, and then they put the car title into the trust name.
If you owe the IRS, can they touch your trust?
So again, the trust, if it's a revocable trust, is just an extension of yourself. So there's no asset protection there from anything, including the IRS. So just like if you own things in your personal name, that's what a revocable trust is. No protection from IRS, just from having a trust. Now, if we have an irrevocable trust, like Joy set up a trust for her son and the IRS is coming after her son, everything in Joy's trust that she set up for her son is shielded and protected from the IRS or any other credit.
Can you put a lien on your family and put them in the trust?
Put a lien on your family, like sue your family?
I don't know. No family left behind. Dead. No family left behind. Rephrase your question. I don't get that one. When you hire an attorney like Charlie, what services would he be providing?
So what I do with my clients is, of course, create the documents, right? And that's what most lawyers do. But with the system that I'm a part of, or the network that I'm a part of, and just so you all know, it's called Personal Family Lawyer. So if you Google Personal Family Lawyer and go to their website, Personal Family Lawyer's website, you can then find a personal family lawyer in your state, in your city. We all have the same training. We all use the same system, and it's designed to make things easier for your family. So in addition to preparing the documents, which any lawyer can do, prepare the documents, we provide so much more where we also sign up to be your personal family lawyer, or if it's a business, personal business lawyer, personal family lawyer in your businesses, where you don't have a stack of papers with all this legalese to turn to. You also have that old school lawyer, attorney on retainer type feel where, okay, I got my trust. I just sold, I'm getting ready to sell a business. What do I do? Let me call my personal family lawyer, Charlie, and see what's the best move here.
Gotcha. Do you do small claims? Court was no. Baby, he said $7.50 an hour, baby. No, he's not in small claims court, okay?
I did back in the day.
Back in the day, back in the day. What you put someone on your trust as far as your kids, do they have to pay taxes on your toy box?
No. I think they're saying, Joy, like if you got a trust for your son, let's say for example, and then you're going, the trust is like, again, like its own entity, so it has its own tax picture, so that the trust itself will pay its own taxes. So if the trust is making income, the trust then reports that income and pays taxes on its own income. If the trust isn't making any income, just like a person, then no taxes to worry about. But that's all within the trust itself and not a burden on the beneficiary.
Okay. If someone passes away and their life insurance lapsed last year when they got sick, but they was paying on it for 30 years, can I fight that? I don't think you can if you let it lapse. You want to look at the contract to see. Sometimes there's a grace period in that lapse. So you want to look at that to see. Can you get funding through your trust?
Yes. Sort of like how a business can build its own credit, get funding. I think that's what they're saying, like get credit maybe or funding. Um, a trust can become its own picture, and that's going to be more with an irrevocable trust, where if you have a trust that's making income off of properties or assets or investments, then it's an entity that can have its own picture there. If it's a revocable trust, then it's just an extension of you, so it's no different than you getting funding for yourself. It's just through the trust indirectly.
Okay. How much is inheritance taxes on a property?
Depends. Yeah.
Go ahead.
Yeah, that's going to depend on the state. Again, North Carolina, where I am, has zero inheritance tax. Just to touch on taxes, I'm not sure if this is what they're getting at too. If someone inherits property, then, so let's say if Joy bought property for $20,000 and then passes away and the property is now worth $500,000, if it's given to her son through a trust, it will be as if he bought it for $500,000, which is good, because then if he turns around, or if that trust turns around and sells it, then there's no capital gains tax. Is that that might be something that they're getting at. Versus if you give property while you're still living, it'll be as if they bought it for the $20,000, and then if they sold it later in the future, they will have to pay that capital gains tax from the $20,000 to the current market value. So that's another benefit of leaving property through trust, where a lot of people, when they get older, especially, they might think of giving property while they're still living to their children, but that's not the best for taxes per se.
On average, how long does it take to create a trust?
So depends on the attorney, but with, again, the personal family lawyer system, when someone makes payment, they automatically get scheduled about 30 days out from payment. And then 2 weeks out from payment, we rehash some details and make sure things are airtight. But about 30 days from payment is when my clients come in and sign all of the paperwork, including the trust.
Okay. And then just to recap, a trust is going to cost you around $1,500 starting. It could be a little bit more depending on how complex the situation is. Can the beneficiary fire the trustee?
Yes, if the so it depends on the trust. So if the person who made the trust says my beneficiary can do that, then they can do that. But what most of my clients do and what most people do, they can't fire the trustee because they chose the trustee for a reason, and they might not want them to just mess that up. But every trust will have, if the trustee is doing anything illegal or wrong, or let's say like if they was using the income or the funds for themselves personally for the beneficiaries, then they can easily get that trustee removed and replaced.
Again, what trust is used to prevent the Corporate Transparency Act? There is no, you cannot prevent the Corporate Transparency Act. Okay, here's the law. The federal government wants to know who owns what entity. Okay, they're trying to crack down on money laundering. They're trying to crack down on people acting like acting like they don't own anything. Okay, if you have an anonymous LLC, then no one knows who owns that LLC. So if you have an LLC in Wyoming, Nevada, New Mexico, Delaware, no one knows who owns the LLC. Okay, so this is why the Corporate Transparency Act came. So now everybody who owns an LLC taxed as an S Corp or a C Corp, you now have to fill out a piece of paper to tell the federal government, I am a member or I am an owner of this entity. There is no getting around it, hence why there's this new law. Okay, but it's the same thing as telling your Secretary of State, when you form your LLC or corporation, it's the same thing as filing your entity on your tax return. You're just telling the federal government, I own, or I am one of the owners of this LLC, corporation, or LLC or corporation tax as an S corp, however you want to cut. There is no getting around it. You're gonna tell the feds you own it. Okay.
And I think the reason for that was because you had all these people, and especially scam artists, making and hiding behind companies, and nobody could see who really was the owner of them.
They're just cracking down on all that stuff. I have a trust, but I am newly divorced. Congratulations. Do I need to change my trust? If the spouse was a beneficiary, you need to change the trust.
Yeah,
right?
Yeah, definitely get that looked at. If that trust was made with the spouse in mind and naming the spouse the beneficiary, and this will be considered a substantial change or a life change, a life event, where you want to make sure estate plan matches the change.
Okay. A trustee is an employee of the trust?
You could think of it like that. It's not legally an employee with like employee taxes or anything like that, workers' compensation. But in theory, the trustee works for the trust on behalf or in benefit to the beneficiary.
Can you be both the beneficiary and the trustee?
You can, but if we have a situation like we said where we have that irrevocable trust and you're trying to have asset protection, it's risky because you could lose that asset protection because someone like me can make an argument, Your Honor, that a trustee and beneficiary, they have control and access. We need to treat it as if they own it in their individual name so that we can basically pierce through that and access this.
Back to Joy's question, when the parent dies and the child gains access to the irrevocable trust, can they amend the trust to a revocable trust and sell the asset?
No, because if they could amend the irrevocable trust, that means it wouldn't be an irrevocable trust. They would have,
Okay.
they can't change or do anything with it once it's an irrevocable trust. The trustee is the one that's going to be making changes and doing things.
Okay. Can you make your children a trustee for your business and beneficiary?
Make the children trustee for the business. So businesses don't have trustees. I'm not sure if the question is worded correctly. I just want to make sure I'm answering it right. Children can be the beneficiary to trust, and they can be trustees. But again, the risk there is losing that asset protection.
So the whole point in forming a trust is kind of like forming a holding company where we kind of want to put like a shield between us and owning the asset. If you have both hands in the toy box, if you're the trustee and the beneficiary, well then basically, baby, there's no need to form a trust because now it's like you're just owning it on both ends. You got to give up one end. Either I'm going to receive the benefit or I'm going to have control over it. If you want to have both, then we're not separating and putting a layer between us for asset protection reasons. Okay. So if you fill your questionnaire out to book a consultation with Charlie, the consultation is going to be free, and he's going to break down, like, some of y'all may not need a trust if you're trying to, hold everything and control everything. When did the See at the Bank t-shirts drop? Girl, I have them on the website. I should have on the website now. Is a trust better than a prenup?
So let's talk about that. A prenup is if I get divorced, what happens? But we had a question earlier where someone said, hey, I just got divorced. What does this mean with my trust? Deal with divorces. A trust is more for different types of planning, like taxes, or for most people, if I pass away, when I pass away, what happens? So they have two different purposes. So they can have a prenup and have a trust.
Do you pay the trustee of your trust?
The trustee can be paid. The trust can pay the trustee. So the person who makes the trust makes that decision. Do you want your trustee to be compensated for their services, or is it just going to be for free? So what most people do, if they're hiring someone, like, let's say I'm gonna name my sister. If I pass away, my sister's gonna be the trustee for my child. They usually are gonna say the trustee does not get paid because it's a family member or a close friend or something like that. If a bank or a company comes in, that's considered a corporate trustee. They're going to automatically be able to get paid because laws allow them to get paid a reasonable fee. Corporate trustee. So most people say no compensation for the trustee if it's someone personal to me, but then a corporate can get paid.
Okay, so we are now at our hour. I cannot keep Charlie here all night. Charlie got stuff to do. But to do a quick recap, Charlie does consultations for people in all states. The consultation is $750, but it's free if you fill out the questionnaire. It's going to basically kind of explain to Charlie all what you're trying to do so that when he meets with you, he'll be able to kind of give you a game plan quickly. So basically, the consultation will be free if you fill out the questionnaire and do your homework. So you put a little effort in, you can get your free consultation with Charlie. Charlie can help you get a game plan for whatever it is that you're trying to do as far as forming a trust for your personal assets, business assets, whatever. If you are in a state outside of North Carolina, you can still have a consultation with Charlie. He can then connect you in this network of other attorneys who are business estate planning attorneys like Charlie, and can help you, so you at least know from Charlie what the game plan is, and then he can refer you to whoever is going to be the attorney that's in your state, okay? Because a trust is dealing with death, like what happens upon your death, every state succession law, is it called succession in North Carolina?
Yeah,
Or heirship?
intestate succession. We call it
Okay. You know, in Louisiana. So each state is different as to what the succession laws, or who gets what when you die, how that works. So that's why it needs to be formed in either a state that you're living in, or see, a trust is you got to sign documents. It's not like we're going to e-doc something. So if you're in North Carolina, if you want to go fly and meet Charlie and have him do everything and sign a dotted line, he can also do your trust. But I believe they have to have a wet signature on the trust to make it official. If not, everybody will just be kind of remixing their own trust. Okay. I am going to save this live for 24 hours. I will put their contact information on there so you can contact them. I can't type it in the comments because my live was just free, but it's going to be on Instagram. He is the Hands Law Firm, or just Hands Law Firm?
Hands Law Firm. HANDS, like your two hands on your body, law firm.
So two hands on your body law firm. Okay, do we have David Hands? Is David still on the line?
Yeah, I think
Is David still on the line?
I saw him earlier on here watching, but yeah, David Hands is definitely here. He's the
Because
founder.
I'm going to have another live, because when it comes to business, we also have to deal with debt. Okay. And I know a lot of times when we hear the word bankruptcy, it kind of scares us, and oh my gosh, and it's the death of me. But bankruptcy, especially if you have assets personally, bankruptcy, especially if you have business assets, is a great way to wipe out that debt, get like a reduction on your monthly payment for the assets you have, and you'll be able to keep your assets and wipe away the debt, right? But people don't talk about that. They just say bankruptcy gonna be in credit for 7 years. No. But there are some benefits in filing bankruptcy, especially if you have assets. Number two, you may have made the wrong move. You may have got the wrong loan and the business just didn't shake. You may have gotten yourself in a shitstorm. It happens to the best of us, okay? There is no need for us to have a heart attack, a stroke, get divorced, do all this because we can't afford to pay this debt, and it just takes us under. Sometimes we have to, do a hard reset. You got to power that phone off. If you get a Nintendo cartridge, you got to, blow on it. Sometimes we just need to do a hard reset, right? And with that Chapter 7 bankruptcy, it's going to just wipe everything off. It's going to give you a clean slate, right? You are going to have a ding on your credit, but you're going to have a clean slate, meaning, let me get my monkeys. These monkeys are not going to be on your neck, right? All those bill collectors calling you, your wife being mad and arguing with Chapter 7 just takes all that stress away, right? Now, your credit score is going to take a hit, but they have credit people that can go ahead and help you rebuild your credit. It's not the end of the world, but the debt is gone. So the stress is gone. You can breathe. The slate is clean. Now we can start a brand new business with a fresh slate. Okay, so there are a lot of benefits of bankruptcy that I feel like our community doesn't understand. We just hear bankruptcy and it's like, no, but bankruptcy, depending on what kind of situation you're in, could be a game changer. It can be what takes you to that next level. Okay, a lot of our favorite Forbes people are filing bankruptcy left and right to protect their assets and wipe out wipe out debt. It is not the end of the world if you file bankruptcy. Okay. And a lot of times, once you get that debt, but more importantly, once you get that monkey off your back, and the arguments are a little less at home, and you can think clearer, now we can actually put our mind and effort into either revamping our business, forming a new business, getting into a new industry, and now we have a fresh, clean slate to take all the learning lessons we had in that old business and put it into something new and thrive. Okay. And you are going to be getting credit card offers left and right after bankruptcy. Bankruptcy is not going to be the end of the world, although that's to me, that is the song and dance that's painted if you don't understand the benefits of bankruptcy. So Charlie's law partner, his name is David Hands. I'm going to have him on a live maybe next week or the following week before Thanksgiving. And so if all my business owners, all these UCC loans, all this debt that we may have incurred, if we are in trucking or transportation and you have signed the dotted line on a factoring company and they're bleeding you, if you are emerged in debt, or if you just are personal debt, you just out of order and got too many cars, too many credit cards, whatever the case may be, if you made a mistake and you want to come back to Jesus and get redeemed, we're going to talk about the benefits of bankruptcy and how it can really change your life for the better by wiping the slate clean and letting you have a fresh plate to start on. Okay, so stay tuned. I will make a post. We're going to do that bankruptcy live. But let me see if I have any more questions. How much is the total fee? Can I establish a trust without a lawyer? You can defend yourself in a murder trial, but should you?
Yeah,
Technically, yes, you can. But see, Charlie went to law school, right, to learn. Can you fill the paperwork out? You can. Do you know what you're filling out? Are you filling out the proper paperwork? Are you funding the trust correctly? You don't want to do something on your own, and then you realize I don't have protection, and then now we have the lawsuit, and now that they done took everything all because you didn't want to have a free consultation with Charlie and pay $1,500. It's like some things you don't want to do. Like you could defend yourself on a murder charge, but should you? It's just some things that we just shouldn't do.
Yeah.
So yes, the average fee is $1,500 to start a trust. Can you re-explain how or to avoid minimizing taxes, baby? It is over an hour. What if the trustee dies during an irrevocable trust?
Oh, that's cool. So the trust will have, you can name successor trustees. If that person dies or that company goes out of business, the next one you name in line will become the trustee. Let's say we go through the whole line and no stuff after the line, right? The beauty of a trust is a trust will never fail for want of a trustee because you don't have a trustee. So worst case scenario, there's no one else left in the list. There's no other trustee. At that point, a court can appoint a trustee over a trust. So the trust doesn't fail. It doesn't disappear or break apart. The trust can still appoint or get a trustee appointed. And that's when the beneficiaries will kind of facilitate that. If it's an asset protection trust or irrevocable trust and we need to get a trustee in place, you can just have one appointed at that point.
Okay. Can a holding company serve as an asset protection measure? Yes, a holding company can, but tonight we're just talking about trust, another way of having asset protection. Can your trust be protected if you get a divorce? If you get a divorce, you're going to need to change your trust.
Yeah, the protection is only going to be if it's an irrevocable trust that you don't have control over.
Okay, so anything irrevocable is protected. Anything revocable is not protected.
Yep.
Okay. Baby, whoever is Stephanie Diamond, baby, you are on it. Stephanie Diamond, I don't know who she is, but baby, she is on as a little moderator. Thank you, Miss Stephanie. You are on it, girl. Thank you. Can you have a revocable and an irrevocable trust?
Yes, you can. So you can have as many trusts as you want. Again, people just have that one revocable trust to start, and that for 99% of people is enough. But then they might have like a duo, irrevocable over here, living trust, revocable trust over there.
So whatever is the game plan that you want to run, I mean, there's more than one way to skin a cat, right? And you want to get what's best for you. Hence, I'm going to put Charlie's contact information when I post this live. Book your consultation, do your form so that it's free. But let him know what tools you're playing with. Like, what assets do you have? What are you about to have? What are you trying to do? And then I'm going to post his Instagram, and I'm going to post his post his website so that you're able to book a consultation with him on the trust. Okay. Now it's an hour and a half. I gotta let Charlie go. He is $7.50 an hour. He got stuff to do. But Charlie, I want to thank you for coming on to share all your knowledge about trust. If you want, I need everyone to follow Charlie. If you hit the little white arrow at the top of the screen, it is at the Hands Law Firm. You can follow him directly from there, or you can go to Hands, like two hands, Hands Law Firm. His website is going to be, is it handslawfirm.com?
Just handslawonline.com.
Handslawonline.com. But I will also put it in the comment when I save this live. Maybe we can get Charlie back for a round 2 of, all these great trust questions. But there's 2 kinds of trust, irrevocable or revocable. We can call the trust anything in the world: real estate, land, Mickey Mouse, your mom's name, a legacy trust. But either it's revocable, meaning I can control the toys in the toy box, or irrevocable. Once I put that toy in the toy box, I no longer have control over it. Okay. I will say this live. You guys came late because Charlie kind of broke down like what a trust was and how you create it and all that good kind of stuff. So now everyone should have a clear understanding of what a trust is. And if we don't have any assets, we at least need to get a living trust, not a will, so that upon our death, whatever we're trying to give to our heirs, they will get that without having to go through probate court, without having wills contested, without having all of the assets lost in probate court with court costs, attorney fees, and all that good stuff. Okay. So once again, if I can get a money sign in the comments to thank Charlie for coming to give us this free game. He didn't come on here saying you got to pay me $99. He came over here to give us this free game as to how we need to get our stuff together, how we can protect our assets, another way of having asset protection. So I want to thank you so much, Attorney Charlie Hands. And I will, of course, link him and put his website up. But y'all need to get these consultations in, okay? Because I don't know if he's going to still keep this free consultation. 2024 is coming. Y'all need to go ahead and get your game plan now. If you cannot afford a trust, at least understand why you need it. So when you do have the money, we're not running to Chanel, we're not running to Tulum, we're not at Dubai turned up. We are running to the Hands Law Firm to get our stuff in order. Okay, let's make 2023, we're getting all of our ducks in a row. We are dotting our I's, crossing our T's. Let's just get our stuff together. If you have kids, we got to have a living trust. What are we passing on to these kids? If you got a grandma, what does grandma have a living trust? She's almost about to be out the door. Is her stuff together? Are y'all gonna be fighting over this one house and the car? Like, let's just get our family's affairs in order for 2023. Okay. Everyone have a great night. I will save this live, and of course, I will see you at the bank. Bye.
See you.